Morning, good afternoon, good evening to our webinar series, Investment Mediation Insights, and today's episode in particular. My name is Frauke Nitschke. I'm Chief Counsel at ICSID, and I have the pleasure of moderating today's session where we will focus on investment mediation, but also on a broader perspective about mediation and dispute settlement and tools to navigate investment relationships prior to the institution of formal litigious proceedings. A note up front on our mediation rules that came into force in 2022. Unlike other ICSID proceedings and frameworks, there is no nationality requirement on the parties and no membership requirement either. If the parties do not have a pre-existing consent to mediate, the Secretariat can transmit an offer to mediate to the other party, inviting that party to state whether it accepts such offer. Other information on our activities in the mediation realm and our background papers on mediation and the treaty analysis is available on our website, and we will put this into the chat. Today, I have the great pleasure of having with me two experts in the field. On the one hand, we have Fahira Brodlea from the GIZ in Bosnia and Herzegovina. Fahira has extensive experience working across the Western Balkans with the states, let me see if I remember them by heart and in alphabetical order: Albania, Bosnia and Herzegovina, Kosovo, Montenegro, North Macedonia, Serbia, and I think that was already 6. And then we have Jadranka Ostrejčak from the Attorney General's Office of Croatia with us. Both of you are also pursuing academic adventures and teach and lecture at a wide range of universities. A note on format for our attendees: please put any questions that you may have into the chat, and we will pick them up at a convenient time during our informal conversation, or certainly we'll look at it to make time at the end. So let's just dive right in. Why should states think about managing investment disputes and engage with problems early on before a dispute settlement clause is actually triggered? So we're not looking at cooling off period here, but we're looking at prior to the triggering of a dispute settlement clause. What are benefits of doing that, and what are losses possibly of not doing that? Fahira, do you want to start us off?
Yes, thank you very much, Frauke, for the kind invitation and the kind introduction. It's really a pleasure to participate in this kind of discourse, because we're obviously trying to find best solutions, and I will be very curious also to hear from participants about their experiences. When it comes to reimagining and rethinking the approach of dispute resolution, dispute settlement, mechanisms, procedures in disputes that involve foreign investors and the state, there has been this long-held paradigm that it must be adversarial, that any kind of issues raised against the state, quote unquote against, will lead then to a formal legal procedure, and then ultimately somebody else will make a decision. But now, as we are more and more moving towards encouraging and inviting renewable, sustainable investments, the kinds of investments that governments would like to retain long term, the ones that really invest not only financially but also strategically, that will necessarily then also require a rethinking of what is done. And the problem here is that states generally, although they might have these different different mechanisms and procedures way before the cooling off period is triggered by a notice of the intent of a dispute, is that for a state, the only experience in these kinds of procedures is the dreaded ISDS. It is the moment when the arbitration starts and they hire the legal team, and then ultimately the tribunal will make a decision. And most of them in our region, for example, have had negative experiences. So no matter what they might have already at their disposal, they somehow, by any kind of implication, they will immediately see ISDS as the only option. However, within their treaties, within their legal systems, within their national laws and their institutions, they already have a wealth of opportunity to explore this earlier stage that you mentioned. And the benefits are ample. First of all, just from a good governance perspective, from the outward perception of the government to foreign investors and those who might already be there or those considering it looks like a system where they can come, have a predictable framework, and access legal remedies if necessary, but that they will also have responsive government agencies and institutions that will address their issues early on. Second, they will generally improve their climate for more sustainable and more, for example, the renewable energy investors, because they already have this breathing mechanism where it goes back and forth over time. It is not just a binary of somebody must always be right, must be wrong. There is this opportunity to recreate the way the system functions and breathes as such. There's also the opportunity to lower actual risks of disputes by early engagement, by being responsive, by not allowing the trigger letters or questions to simply linger or go between different institutions without knowing where they need to land, they can actually reduce the risk of actual disputes coming up. And when it comes to the potential, lost opportunities, one thing I always raise and bring up is that it is one thing to address something that you have heard, so you know there might be an issue and you are addressing it by an investor who is already there. It's a whole different thing when there is an investor somewhere else who has not yet reached out to you, but is looking at your system, not only your natural resources or what might make sense for them as as an investor, but they might actually lose interest if they don't see at least some kind of inkling of a framework of a responsive mechanism where they do not also have to go to litigation or arbitration, where they can safeguard their interest but still have their issues addressed. So this is absolutely a topic of wide discussion, and we can go on uh, much deeper, but I think just to give you a general idea, this would be it. There is multiple and very tangible benefits just outside the door, but we just have to reimagine how we approach this.
Mhm. So there are benefits to a particular dispute, but as you laid out, also it may have a halo effect
Yeah.
for investors considering investing. What is the framework if disputes or problems arise? How does the government engage? Jadranka, anything to add from your end on this wide questions? What are benefits of engaging and what are possible losses of not engaging?
Thank you, Frauke. It's really lovely to be with you today and participate in this webinar. So I'm going to address this question from the state's perspective and a more practical angle. States care about their investment rating and direct foreign investment. So they don't want to lose good investment and money, especially once the investment has kicked off, unless the investment itself is illegal, which is obviously a completely different story. So engaging with the problem as early as possible is important, as already Fahira emphasized. And this is why many times we see that states set up investment agencies or similar state bodies in which investors can not only get information how to set up the investment, but also raise concerns with respect to emerging disputes. Croatia used to have such an agency at the beginning of 2000s. And it is paramount that state officials addressing disputes have a positive approach as to the amicable dispute settlement in this phase. And although a state might find itself in a legal battle, this is not a moment to act as though the investor and the state are on the battlefield. So right now, at that stage, the investor and the state bodies and the state stakeholders should try to negotiate and discuss. And furthermore, many times a dispute between an investor and a state or state entity can be resolved if parties start talking and negotiating, especially if there is a direct channel of communication between state officials and the investor. So as I mentioned, not every dispute needs to be and is a legal dispute, and not every dispute needs to become as such a legal dispute. In other words, early engagement in conversation can prevent a dispute from becoming a legal dispute and a battlefield. So what, and the last but not least, and this is important for states, this informal period should be also used for case assessment, for gathering evidence, for establishing facts, and for detecting possible witnesses. So this informal proceedings is very relaxed proceedings, so states should try to benefit from it. And what are the losses of not doing that? The losses are multifaceted. So by ignoring a dispute, state is sending a message to the investor that is in the dispute with the state and all the other investors that disputes can only be resolved in previously agreed upon procedure, usually investment arbitration. Such approach exposes both parties to protracted legal battles and high costs. It can also be very damaging for the case because it might be more difficult to gather evidence and identify possible witnesses once the official proceedings have commenced. And finally, looking at such approach from a broader angle, I would say that it undermines the rule of law, unwillingness to negotiate and discuss.
Thank you, Jadranka, for laying out the different tracks. On the one hand, the legal battle, as you described it, the legal translation of a dispute into a legal framework. That doesn't necessarily mean that the other track of negotiation is closed off, and to look at it from a time perspective, early engagement, direct communication, even if there is a later proceeding, is really relevant for the state to gather information to make conscious choices which track to pursue. Now, if we look at like the range of disputes that can arise, the range of industry sectors involved, the range of government entities that might be involved on a ministerial or national government level to a municipality level to special agency, so a wide range of maybe dispute origin. How can these disputes actually be managed when it's so multifold? Is there data gathering needed? What are structures that could be put in place? And what are functions that may need to be covered? How could our audience envision that? Fahira, maybe you want to start us with some thoughts on that?
Thank you, Frauke. Yes, absolutely. The good thing about, although you have outlined quite a complexity, and that is in the most simple governmental structures, let alone federal states like Bosnia and Herzegovina, for example, where you have 13 government levels, each of which has their own competencies. Now, the good thing about having different functions and different competencies is that there's an institution assigned for each. So governments that are trying to consider maybe establishing a coordination and an early response mechanism or dispute prevention mechanism mostly find it very daunting because they think inherently, and judging from the proposed models that they have now at their disposal, that it might take a lot of work in actually either expanding the work of the existing institutions or coming up with a brand new system, which is not always the case. Usually governments already have everything they have with everything they will need within their framework already, number one, and number two, the competent government officials already do this work to a certain degree, but they don't see it as contributing to dispute prevention or dispute management before you have a dispute formally notified. So what they really need to do is make an assessment, and this is where the data gathering comes that you mentioned. So do a mapping and establish, first of all, what is it that these different institutions in this matrix do? Then take a look at the kinds of issues that they hear from, that they face, and that they resolve. So what sectors, what investors, what are the values, what kinds of treaties, which treaties are triggered the most, which locations, what kind of projects are the most sensitive, but then also do the mapping of the applicable treaties, contracts, legislation, and very importantly, previous conflicts and previous ISDS disputes. So put all of this wealth of information that you already have in your government, map it out, and then all you need to do is curate. So it's not really about necessarily establishing new institutions or new offices or adding more work. It's really about curating how these different existing institutional frameworks mutually collaborate. So matching the structural and procedural reforms to the institutional framework, and then bring it to life with a standard operating procedure. That's the key element. That's the magic factor. Making a very clear pathway for communication and coordination from the first point of entry of the information about a potential grievance or existing grievance, then how the information goes through the blood work of the government, making sure everybody is informed at the same time, but activating those who can intervene in that moment. So you can have a focal point, perhaps the Foreign Investment Protection Agency, that serves as this filter and information gatherer and distributor. Then you may have a coordination body, and I'm sure Jadranka can give excellent examples. Um, a coordination body that constitutes of the competent ministries that are always involved and the state attorney's office, and then ad hoc members that really relate to the specific dispute, the sector, those who can provide the expertise, the technical information to those making the decision about possible settlements or resolutions early on. And during this whole time, the focal point will transfer information back and forth so that the investors don't feel that they are in the dark or that nothing is happening at the government side. And most importantly, because of the risk and very real fear of those who might want to engage in amicable settlement, is that they might face political but even legal repercussions later on. Having a coordinated and joint decision-making process where solutions and recommendations are made by all the competent institutions, then also shields them from being the individuals who come up with certain, solutions or settlements with the investor, which might then, raise either for political gains or for whatever other motivation, might raise questions about why and why them that they have tried to engage with the investors. But regardless of what is done, the governments, when they're imagining these mechanisms, need to step back from the necessarily defensive posture that they have and regulating in the negative, so regulating from something and trying to get away from something, and really opening up, engaging, inviting earlier solutions to the extent possible, and being very clear on how and when different mechanisms are activated.
Thank you. Thank you, Fahira. And you certainly have not only worked in the very complex structure of Bosnia and Herzegovina, but also in other states, and have advised on that topic and worked together with the governments, setting out that we do a data gathering at the beginning, looking at where are these issues? Do they focus on a particular sector, investors in a particular area, or an agency? And then from there, build on that, like on a country profile, if you will. And then if I heard you right, you look, of course, on the legal framework and assess, and looking at, on the one hand, the outward communication, but also the coordination within the government, which is certainly important for information gathering, that Jadranka had also touched upon in her first response. Jadranka, can you give us an example? How does this work in Croatia?
Thank you, Fahira. Yeah, you and Fahira, thank you, Frauke, sorry. You and Fahira actually set the scene perfectly to continue discussing how this can be managed and how this can be done in practice. And I agree with both of you, data gathering is crucial, and so is gathering of potential evidence, especially like, for example, email correspondence and notes, because they can easily be destroyed. So you want to preserve all the evidence as early as possible. And furthermore, state entities and municipalities need to be informed of all disputes that relate to their scope of work and are within their competence, because obviously they'll be able to participate in resolving the dispute, but also they will be able to improve their work. But let me go one step back and explain how dispute prevention operates in Croatia. So in Croatia, we have a special committee for dealing with investment disputes, and the committee was established in 2013 by the government decree. And the committee has been working since, and throughout more than 12 years since it was established, it has addressed many investment disputes. Just to give you the new information which I got like a few days ago, just last year, it dealt with 2 potential investment arbitrations. I knew about the outcome of the one, so the one of the disputes I was involved in as well has been resolved, and the investor decided to continue its investment in Croatia. And with respect to the other, the committee rejected the investor's request. However, the committee provided a reasoned decision, and the investor has not filed a request for arbitration or initiated arbitration in other ways. So we can consider the work of the committee very successful. And the reason why the committee is successful is because it is comprised by state officials from several ministries, all closely connected with development of foreign investment in Croatia, particularly State Secretary from the Ministry of Foreign Affairs, of Finance, of Justice, and of Economy. And one permanent member is also a deputy of the Attorney General, because State Attorney Office of the Republic of Croatia represents the state in international arbitration. So you see all the participants in the committee are actually in a certain way involved in disputes and resolving of disputes. And the fact that the committee has been operational for over 12 years and has resolved many disputes gives it legitimacy to investors as well. So, and finally, that's the final remark for this part of discussion. The committee does not have the power to settle disputes. It gives recommendation to the government to settle the case, but the fact that it is comprised of state officials gives it credibility with respect to investors, but also the government.
Thank you, Jadranka. Thank you for bringing that to life in Croatia. And we certainly have seen a number of ICSID arbitrations settle involving Croatia. So you described the committee and the different ministries that are involved, and then the committee itself provides reasons to the government to engage. And we'll may touch upon negotiation authority and settlement authority maybe in a little bit, and how the institutional framework gives that credibility, perhaps attaching to that the halo effect that we spoke earlier, that if there is an issue, there is a framework that investors could turn to. Now, given that we are within our investment mediation series, is there a policy on the state level to engage in negotiation or facilitated negotiations such as mediation on a treaty level in the domestic legal framework, or possibly in contracts concluded by the state? Maybe, Jadranka, you could start us off with the Croatian example.
Thank you, Frauke. I have already talked about the committee and its work. So, as you mentioned, it would be good to emphasize yet another facet of the topic we are discussing today, and that is the question of whether the amicable settlement of disputes is inherent to a state's legal culture. When it comes to Croatia, the answer is yes, and I would say that it relates to all EU member states. Now, I strongly believe that negotiations, mediation, and other aspects of amicable settlement of disputes need to be developed and nourished. And this is something that we see on the state, EU, and international level, as you, Frauke, already mentioned. Furthermore, mediation is, according to the Croatian Civil Procedure Act, mandatory when one of the parties is in a future litigation is the state. So if Croatia is going to be a party in litigation, then according to the Civil Procedure Act, parties are required to try to settle a dispute amicably. The reason I mentioned all of this is because the legal culture plays a role in state representatives' positive approach to amicable dispute settlement. And I think that if state representatives at some point of time are involved in amicable dispute settlement on a daily level, then the state and obviously the state representatives will be more open to such solution because it has become a part of them, of their legal culture.
Thank you, Jadranka. Fahira, your thoughts from the Western Balkan regions at policy level?
Yes, thank you very much, Jadranka. I would just like to bring it back again. And Jadranka does it very well, but from the state perspective, we have seen, for example, in the development of the ICSID Convention and also in the bilateral investment treaties, which largely provide for a multi-tiered framework. And at ICSID, it was conciliation that was really prominent and an important factor as a thought about how to structure dispute resolution between states and foreign investors. So there is no doubt that amicable settlement and attempts to avoid any kind of confrontation to try to settle early have been in the mind frame of states over the historical development of this framework. However, we are also faced with the reality of what it means to be a functioning state and facing either problems, grievances, and as they evolve towards potential legal disputes. States often face really bad experiences, and there are some investors with whom settlements are not possible. So, especially for the governments that have very, very little, few cases, but most of them being bad and with bad investors, they never had a playing ground to test. What is it like to really just face an investor who has a problem, who needs a solution, and once it's solved, we move on? Usually, there's very deeply entrenched and complex background stories that prevents the government from actually even attempting something with a particular investor because of all of those circumstances. So we have to be mindful of the broader issues. But the other kind of factor that slows down and does not allow the full use and full benefit of amicable settlement is the fact that there is a broadening disconnect between those who legislate and negotiate for treaty and legal statutory language that involves mediation. So we see the clauses saying you should attempt mediation, but that is a long way to go from what those representing the government in investment disputes need. What kind of information and authorization and procedures do I need to effectively engage in this process and know my role as a government representative? What is it that, how do I position myself? What do I do? With whom do I connect? Usually in these discussions and when the negotiations happen, mediation and all pre-arbitration steps are treated like a magical formula. So by putting it there, putting the word into your clause, that means you have everything you need to actually do it right. In the meantime, there is no clarity about how it's properly initiated. Do we have rules? What kind of rules do we want? How do we pick the mediators? How does the process flow? How do we communicate in the meantime? Is it a condition precedent or not? If we're not successful in the mediation, what is the threshold for us to say we actually attempted it? Aside from just the timing and saying 6 months or 3 months, so much needs to be fed into these clauses for those who will actually try to practice mediation and who would like to engage from a government perspective to know what to do. And I have had experiences, for example, when we're trying to organize trainings for different kinds of institutions where we got responses from some institutions saying, well, don't worry, we have ADR centers in our government that have mediators. So some government officials think that they are the ones to be the mediators in these disputes. They haven't even put themselves in the mind frame of being a party in amicable settlement, being on the other side of the mediator and trying to come up with a solution. There is so much to be done without, we should not be, I guess my point is, we should not be comforted by the fact that we are seeing many more clauses referring to mediation, and there needs to be a lot more done to operationalize it, to give it everything it needs to actually function in practice.
And that was precisely the idea behind the ICSID mediation provisions, to provide implementation options for references to mediation in these treaties. You made an important point at the beginning about the settlement, and I just want to get that clear for our webinar here, is that willingness to negotiate and assessing whether this is in the interest of the state is the starting point. So we are not here to argue that every dispute should be settled, but it needs to be a conscious choice and an analysis for the interest of the state, if that is in the state's benefits. And differentiating between the policy level and the implementation. We touched upon a couple of times on the negotiation authority and settlement authority. Jadranka explained the committee doesn't settle but make a recommendation in Croatia. This was a point that we addressed in the mediation rules in Mediation Rule 20. On the one hand, on the settlement process, that this is identified early on within the mediation to link the negotiations to an eventual settlement, knowing well that at the beginning you do not yet know how a settlement could look like, who all may need to sign off, but to start thinking about and putting something in place for that eventual. Different from that is the negotiation authority, who actually engages in the mediation, who participates, and this is typically addressed with the mediator at the outset of the mediation as well. But assuming that, how is negotiation authority and settlement authority handled? Jadranka, do you want to start to us off with Croatian example?
Yes, thank you, Frauke. Yeah, so for Croatia, we don't have any particular process in place. And as you rightly mentioned, negotiating authority and settlement authority are two different bodies in Croatia, and the committee I talked about is a negotiating authority. So it is the one that talks to the aggrieved investor in a very informal way, and it is trying to negotiate the best possible solution for the state and the investor. If, however, the committee reaches the conclusion that the state should settle the case by paying, for example, damages, then the government takes over, and it is the government that will enter into the settlement agreement with the investor. Why? Because the government has the power to create obligations for the state budget. It is not the committee that is empowered to do so. Is it possible to have a situation in which the settlement authority will be some other body and not the government, or is it possible to have a situation to have several settlement authorities? Yes, of course it is possible. Let's just imagine that the settlement relates to a piece of land owned by the municipality. If that piece of land is part of the settlement, then obviously one of the settlement authorities will be the municipality, as this is the owner. It is the owner of that piece of land. And finally, regardless of which entity is settling the case, the settlement needs to be lawful. It needs to be supported by evidence as to the amount of money that is paid to the owner, as to the ownership, etc. And it needs to be in accordance, obviously, with restraints provided for in the financial regulations of state budget.
And that is assessed by the committee, and that is why you have the different members in there from finance, from economy, from the Attorney General's office. Do I hear that right?
Yes, yes, of course.
So it's a comprehensive approach to the assessment of the settlement and really the interest of the state. And by doing that so comprehensively, I would assume one of the aspects is to ensure that it's in the benefit of the state and makes it politically viable.
Most certainly, most certainly, and legal.
Do you have an aspect of that about publications of settlements as well?
So far, we've just published the outcome of outcome of disputes. We haven't published the amount of the amount
not the
one
details.
takes.
That's
Yeah,
right.
not the details.
Yeah, the media strategy here and the timing of settlements, that is something that is certainly to consider as well. Fahira, do you want to add from your experience?
Yes, absolutely. I mean, generally, this will depend on how mature the dispute itself is. So are we talking about something that is already evolving through the process to the different institutions as something that could actually become a legal dispute? Or are we talking about something at the operational level that requires technical knowledge that can be handled even by the municipal or sub-government divisions themselves? So the earlier they are in this kind of timeline, the less transparency there is about what really happened. So all we know is ultimately, if we even know that something happened, it usually that's what is considered this earliest kind of settlement. And the kind of loss there is that usually it's not possible then to quantify just how much was done and how much these early interventions have saved, not only by preventing the disputes, but also retaining the investment, retaining the jobs, and contributing to the broader framework. So we don't really know much except for the fact that on many occasions, the local institutions and agencies are the ones that handle these things. So there is not much coordination or communication otherwise, or reaching out to higher entities for these settlement decisions. But the higher that we go, up to the state attorney's office, that's where things become more formal, and that's where the opportunities are missed, because usually as soon as the state attorney's office is aware of something that might become a dispute, it is treated as a dispute. That is where we have seen governments already hiring legal teams. So I'm not really sure we can even talk about proper attempts of settlement. And the state attorney's office, as soon as they are engaged, they see themselves as representing the governments in legal proceedings which are adversarial. So there is a gap there as well, and I have not seen too many pre-established uh, and clear, most importantly, clear and transparent allocations of negotiation and settlement authorities. It all becomes more, mm, more, it tilts towards dispute resolution the higher up it goes, and usually since the statutes applicable in our region at least provided the only institution that can represent the government in these disputes is the state attorney's office or some parallel institution of that kind. We have not yet been able to see actually what are the options and opportunities there um, to take advantage of this.
And it could very well be that negotiation authority and settlement authority, the two different concepts, are handled in different ways if there is no established function assigned to the committee, as in the example from Croatia. So we have
Exactly.
seen that in practice, that authority is given from the highest point in government for negotiation on a particular dispute. That
Yeah,
doesn't need to
and
be a standing negotiation. And then what we have also seen in the mediations is that the settlement authority and the process, much like what Jadranka explained, can be involving different government entities, not only the executive, but it could go to another office or a court review to ensure that the state's interests and the legality of the settlement are all complied with. So there are options, and experienced mediators can assist parties with that. Fahir?
and I'm sorry, Frauke, I just what you mentioned about communication earlier, I just wanted to make sure we tie it up again to this, because on the one hand, it is possible then to manage this perfectly, and like you said, to raise it and to have the committee being the workshop for the actual negotiated settlement that's being proposed. However, if there is not good coordination and communication between the local institutions and those at the top, hopefully in some kind of coordination body, the public statements made in for political reasons in this interim period, when it might not be clear, are we even trying to settle, who is trying to settle, who has the authority to decide this kind of dispute, there is an instinct of being defensive and trying to find political shields from responsibility of whatever outcome we have in the end. And that's where public communications by different government institutions at different levels can actually exacerbate disputes. They can make them, they can expedite them towards a formal arbitration. They can also damage the government in the arbitration proceedings. So I'm sorry for if there's any background noise. But it's very important to be sensitive and careful in how the public communication and messaging goes. And it needs to be a unified towards the outside. It needs to be unified and in the interest of the state.
The media approach, yeah. And in these last few minutes that we have within our webinar, I have two more questions for you. What is the relationship between the entity managing investment disputes early on, if there is one, or efforts at managing the investment disputes, and the team representing the state in an informal, let's say, arbitration proceeding? Jadranka, how does that work in Croatia?
So the relationship is due to the state attorney office's role of representative of the state in civil and administrative proceedings and the committee's work and a member, because deputy state attorney is also a member of the committee. It is a relationship of cooperation. So the state attorney office is closely working with the committee because it is involved in the work of the committee. I might just add one sentence regarding what Fahira mentioned. So it is quite clear when Croatia is going to engage a legal help, lawyers, when it comes to arbitration. We actually engage lawyers and law offices once we receive a request for arbitration or notice of arbitration. So the proceedings up until then are very informal, and you actually have a strong signal from Croatian law saying that, stating that Croatia will engage legal help only once it receives request for arbitration and or notice of arbitration. And as I already mentioned, the committee starts analyzing the case as soon as the aggrieved investor approaches it. So that means that the state attorney office, in cooperation with other members of the committee, is working on gathering evidence, identifying potential witnesses and expert witnesses. And this is important because, as I mentioned, the state attorney office is preparing for formal proceedings and is also making sure that there is cooperation between all stakeholders in the dispute.
So engaging the team that will represent the state in formal, let's say, arbitration proceeding, and involving that team already at the beginning is beneficial to the state in that you have gathered the evidence, you are in possession of information that can inform you whether settlement is desirable and which strategy to follow. Fahira, is that what you see across the experience that you have, that teams involving in the investment management are also involved in the team representing? And what are your thoughts on the topic?
Well, generally, I wish there was more on the pre-dispute and amicable settlement engagement and coordination with external legal teams. So the governments in the Western Balkans usually do need to hire external counsel, and the state attorney's office, as the sole representative of the government, does need external support, especially on the international side, and those who are much more experienced simply in this dynamic of investment arbitration. That is the lens through which they seek their external counsel. So we have not seen, it might be happening, we have not seen that early engagement that is prompted by or supported by external counsel as such. They are doing excellent work generally, but that is not the crux of their work. That's not the approach that is being sought. So generally, like Jadranka mentioned, there is a good air of collaboration. There could be more, especially post post-dispute. So if we can do a reverse engineering of what could have been done better even before we trigger arbitration, what if we reconsidered certain areas? Could we have mitigated this part of the claim or removed this part of the claim by negotiating it? So there could be more done there afterwards, and governments as sovereigns can simply just add this as a component of their collaboration with external counsel, so that there is an expectations after the dispute to see what could have been done and how certain matters could have been avoided through amicable settlement as such. But as I mentioned, we are still living and functioning in these paradigms that have been well established, and there are still open wounds and sensitivities in the governments that prevent them from taking full advantage of what's available to them. And generally, hiring of external counsel does not necessarily have to be a shift to adversarial proceedings. There is much more to be explored in this area as well, but it will take some time.
Yeah, and just to clarify, within the government, leaving aside external representation within the government, those entities that are involved in the early management of the dispute are actually quite helpful, if I heard you right, to provide
Absolutely.
information to the Attorney General's office in the context of an ongoing procedure. Is that right?
Absolutely, because this is the wealth of knowledge. This is the kind of factual background and context that the state attorney's office will need when they're crafting their legal arguments. And this is not only important in the pre-dispute phase. We are talking, much deeper into the process itself if we do go to the next step of adjudication, arbitration, or anything, because there will be requests either from the tribunal or from their legal team for continuous provision of information, for coordination. And there is no space there to add additional delays or complexities because an institution or agency does not want to be involved, or they are unclear on whether or not they have the competency or relevance to provide something. And the only way for them to properly contribute and function in this area is to have a pre-established, again, standard procedure so that they know exactly why they are being contacted. It's not any implication of their liability. It simply means you have information that will help the government properly defend its case, and the sooner we get it, the better we will be off. And just one more very important point, it does not even have to end after we have a judgment or an award. So mediation and amicable settlement can help us reimagine and consider alternative means of implementing a decision that was imposed on the parties. It does not have to be binary again. We can, to the extent possible again, and you never know, it depends on case by case basis, but all of the institutions should work in concert to try to get the best interest for the government out of it. So a loss may not necessarily be a loss if you take advantage of the mechanisms available.
And we certainly have seen that in practice, that there is a possibility and has happened in practice to mediate, for example, even after an award is rendered. We have a question in the chat. With regard to investor-state mediation, is there any data within ICSID proceedings on the number of disputes that proceed to mediation prior to arbitration and or are ultimately resolved through mediation? I can start with the empirical data that we have gathered. We have identified over 40 investment mediations that have taken place, most of which were conducted on the basis of a contractual provision or an ad hoc agreement to mediation concluded post-dispute. And these have taken place before, in parallel to arbitration, and also after an award has been rendered. The success rate generally from the data that we have is around 60%. So that 60% relates to the entirety of the dispute. In some instances, parties have settled part of the dispute and then made the arbitration leaner, if you will, cost and time effective, because there were less aspects to be decided. I hope that answers our question. We have one more a quick one for both of you. Jadranka, why don't you share with us your thoughts on what can investors do? We talked a lot about the state's perspective, but what can investors do when a problem arises? Any do's or don'ts from your experience?
Thank you, Frauke. So investors can do a lot. They play a huge role because if the investors are not ready to talk about the problem, if their conversation is exclusively going through their lawyers, the channel of communication is through their lawyers, it might be difficult to fully comprehend the case at hand and reach the settlement. And by saying that, I'm not trying to say that investors should not use services of lawyers. I'm simply saying that sometimes it might be easier to discuss the issues in an informal and relaxed environment. That's why the procedure before the committee is so relaxed and informal. So what would be do's or don'ts from my experience? I would always advise that regardless of whether you are on the investors or state sides, to consider discussing all issues openly. You might want to establish whether the investor is willing to continue the investment if you are negotiating on the state side, because this might add to your perspective. It is not obviously the same if the investor is simply wants to get damages and leave the country, or if the investor is seeking solutions. And I think that if you are the investor that wants to continue your investment, then you need to clearly communicate that to the state in these informal proceedings and during the negotiations. And finally, if you are the investor in the story, please make sure that you are informed of constraints the state might face when negotiating. Make sure that the timing is right, or that you have at least considered timing, because as we all know, sometimes the decision to settle the case depends on facts, whether it falls into the re-election or pre-election objectives, type of industry, public opinion, factual metrics, etc. So these would be my do's or don'ts from my experience.
Thank you, Jadranka. Fahira?
Yeah, I mean, Jadranka, absolutely. You have covered most of the important hints and tips we could give in this very complex and unusual relationship that investors have with states in this area. But I do have 2 points still kind of naturally flowing for what you mentioned. Number one, don't take it for granted that the government institution that you are reaching out to understands what you want. Just be very clear in your communication that the fact you are reaching out with an issue and maybe even proposing a settlement or negotiation is not the kind that they have experienced and that is triggering potential for legal disputes. So be clear. What I'm doing here is I'm coming to you with a very concrete problem, and I would really like to explore solutions. So I'm reaching out to you, but if it's not you, be patient, while the government institutions coordinate between themselves who is it that can actually speak to you on this and who has the proper channels of discourse. So understand that it's not as black and white because you expect a concrete answer immediately. That's number one, so framing. And number two, again, big picture. None of these investments, especially those now that relate to renewable energy and those that are meant to be long term and actually a part of the public policy of moving and transitioning to a better framework and not an obstacle to it necessarily. This means that you are coming in and you are meant to stay for a long time. But on the other hand, if you're asking the government to give you a solution for your issue, who says that the institution you're talking to possesses the kind of expertise of engineering or any kind of other solution that could actually help you overcome it. And maybe they would like to regulate and allow you to do certain things in a more effective way, but don't have the proper framing or knowledge. So as you are approaching institution, come with potential solutions. Come to them with alternatives to the way you are implementing something or framing the way you implement the project in terms of time, in terms of cost allocation, in terms of method, in terms of the way you structure or reallocate or repurpose your financial or actual real estate or plans that you are using. So come to the government with a clear understanding of what's the issue, but also what is it that they can do, what kind of alternative solutions we might have, because it's not always clear from the government side. So this kind of, the little things that could actually decode a lot of this conversation can then ultimately determine how successful you are when you try to find a solution. Otherwise, you're just talking past each other, or even worse, only one side is trying to establish a discourse while the other one is not even responding.
Thank you, Fahira, for your thoughts on the investor side. We have one more question in the chat, whether we have infos on the kinds of settlement that we have seen in the investment area. To what extent they involve new deals or financial payments. I can start with that, and if you'd like to add, I'll give you the floor too. We have done this, or in the process of concluding, this is still my goal, a settlement analysis of over 160 arbitrations that ended in settlements, and identified the information on the settlement, and there are a number of these have a financial payment component, but equally important are aspects for settlement that contain a transfer of shares between the investor, a new creation of a joint venture, a different joint venture involving the investor and a state entity, renegotiation of certain parts of a concession, longer duration or different royalty distributions or production targets. So we have seen a wide range of settlement options, and that's a nice segue back to what Fahira just mentioned, to look at what is the actual goal within the settlement. Is it an exit? And even an exit of an investor could be amicably negotiated, or is it a continuation, and on what terms? We are far over the time, but Jadranka and Fahira, do you have an example of a settlement aspect that you wanted to share, or we have one more question otherwise?
But I think you have covered most of it. I think generally it will just depend on whether the investment is viable in the future. So if we are really proceeding with energy transition and there's a fossil fuel investor with whom we are just trying to settle a dispute, that's I think where you will see more of the monetary payouts, because unless there's a way to repurpose that plant and to shift it towards renewable energy, those kinds of investors are no longer they can no longer conduct their operations there. But otherwise, it's a very broad spectrum of things that can be pursued, and governments will know what to do.
Very good. We have one final question. Does a state's role in reaching out to an investor impact the dispute reward? Maybe like the dispute more generally? Or Fahira, you're nodding already. I hand you the floor.
Yes, one of the major complaints that states have about generally, I mean, there's this lingering discomfort with an investor-state dispute resolution. Like, why is it and how is it possible that these private companies are suing the government? And we have seen, it's an undeniable fact that investors are really coming with claims that run into the billions, that go beyond any kind of reasonable assessment of the damage claim, and they also look for loss opportunities, and governments are really aggrieved by this. But reaching out, even after the arbitration process has started, and trying to phase the dispute resolution process as to assess whether or not certain claims should be maintained or reduced or otherwise eliminated, it can really make a difference in the amount that the tribunal can ultimately award, because as the investor might reconsider, they might reduce the amount of claims that they are seeking, and we have seen this in practice around the world. And then ultimately, once the tribunal has a chance to assess the remaining legal issues and actual compensation, you can see quite a reduction and maybe even more acceptable outcome from the arbitration itself.
Which brings us back where we started at the beginning about the different tracks of engaging with a dispute. On the one hand, on the legal aspect, the legal track, perhaps the other on an interest or commercial aspect, and merging the two possibly could bring the benefits for the parties involved. That concludes our webinar. I thank our two panelists, and I look forward to welcoming our audience to our next webinar in April, where we will touch upon again the aspect of mediation and dispute prevention in another episode. With that, thank you and goodbye.